down. Getting back to the point here, you have the legislature being given plenary power to enact a comprehensive workers' compensation system, basically the absolute authority to legislate workers' compensation benefits for employees as they see fit. This is in the Constitution. It was provided to the Constitution in 1918 through a similar type of amendment through an initiative, I believe. And now you have Proposition 22, which is another initiative that it doesn't amend the Constitution. It's a statutory provision that changes the law to make rideshare drivers independent contractors, not employees. Now, can the people, through an initiative statute, override the constitutional authority of the legislature? Well, Uber and Lyft's lawyers are arguing that they have that the initiative has the same authority as the legislature to change the law, and that therefore, since the legislature could change it, therefore the people could change it. But that conflicts with the part of the Constitution that gives the legislature the authority to enact these laws, workers' compensation laws. So I was playing a portion of the oral argument from back on December 13th, 2022. The appellate court, the courts of appeal have 90 days to issue a decision. We're going to be coming up on that 90th day here, I think on, I haven't counted the exact days, but it's going to be around the 13th of March. So it's probably coming out any day now. So let's go ahead and play this, and I want everybody to see this lawyer, Cronland. He's a great attorney. He does a really good job arguing this point. He basically sends Uber's lawyers into a panic on rebuttal. This guy just destroys it. Let's listen to what he has to say, and maybe you'll get you'll understand the points that I'm making more once you hear Mr. Cronland explain them, because he just does such a great job. I even emailed him and I said, dude, you are a great lawyer. Listen to this guy destroy Uber and Lyft.
That rule won't apply. It just says we're not going there, essentially. It says you just look at the relevant provisions of the Constitution, essentially. It's a pretty vanilla footnote in my view. I don't think you can read that much into it other than the court is saying we're not going to say anything about a case that's not before us.
It recognized it was a different question, and it said how to decide the question, which I agree. You apply the language of the relevant constitutional provision to the particular statute.
And it's not saying, it doesn't say the ones we're discussing here don't apply, does it?
It doesn't say they don't apply, but when we apply the language of this constitutional provision, which says that the legislature has plenary authority, unlimited by any provision of the Constitution, to provide a complete system of workers' compensation.
If in the process that ultimately produced AB 5, there had been an amendment which was passed and became one of the sections of AB 5 that provides for exactly what Prop 22 does. Would the legislature have had the power to do that?
Yes, the legislature did not have to regulate to the full extent of its authority.
Why can't the people do it? If the legislature
Here it is right here.
could have adopted Prop 22 as one of its many exemptions, why can't the people exercising their coextensive power do the same thing?
It's not coextensive in the sense that the legislature couldn't take away its own constitutional authority to do the thing the Constitution says it has the unlimited authority to do, and that's provide workers' compensation. Prop 22 is effectively repealing a constitutional grant of authority to the legislature that the Constitution says is unlimited by any provision of the Constitution. The initiative power was already there.
That's essentially the same language, though, that is in the IEP case, right?
That is correct. And the court didn't say, in footnote 9, it said it wasn't saying that it would have been okay for a statutory initiative to take authority away from the PUC that the legislature had granted and prevent the legislature from doing what the Constitution says the legislature can do. This was a constitutional amendment. It's unusual language. This is not
Oh, so basically, the statute enacted through the initiative can't override the Constitution's grant of power to the legislature to do its job. I mean, this is just clear as day. This is what we've been talking about all along. This is what the Alameda County Superior Court judge was saying when he struck it down as unconstitutional. Now we've been living with this for the last couple of years. We've been fighting it out in court. We got Cronland up there destroying Uber and Lyft, thank God. Woohoo! Because it's true. We have a Constitution. The Constitution gives the legislature the power to enact workers' compensation laws. It doesn't give anybody else the power. It gives the legislature the power. So the people, although there's other parts of the Constitution that say that the initiative is on par or equivalent to the legislature in its power to enact laws, the Constitution says that amendment, that constitutional provision cannot limit the constitutional provision that gives the legislature the authority. So the judges here are being really smart, and they're asking the right questions, and Mr. Cronland is answering them at every single turn. We can go on and listen to this if anybody's interested. I'll keep playing it. We can continue to go through some more discussion here.
I mean, the argument that's made here, starts really from first principles, that in 1911, the people restored to themselves a legislative power that they had at the founding, and that for that reason, if the people decide that they want to go beyond what the legislature has done, they want to change it, alter it, they come first. And that's,
this is the initiative.
The fundamental principles in this area.
The initiative part of the Constitution says that.
Do suggest that there's great merit to that argument.
That is what happened in 1911. And then 7 years later, in 1918, the legislature proposed a constitutional amendment asking the people to grant to the legislature plenary power in this particular area that was unlimited.
There's an interesting debate that, well, it's not much of a debate. I mean, even the Matthews case and many other sources suggest that there was a very specific purpose for that 1918 language, which was to ensure that any Lochner-type challenges would fail.
That was the impetus, but I distinguish between the impetus for a measure and the intent. The impetus was to protect the existing workers' comp system from Lochner-era substantive due process challenges. But when the legislature put it on the ballot, it was broader. It gave the legislature authority that could be exercised into the future.
So if we apply the conventional way of, I mean, many cases lay down this rule, that there's got to be a clear statement. If we're going to have a pro tanto repeal, and that's what you're talking about with subsequent legislation, there's got to be a clear statement that that's what the 1918 statute was doing.
What all those cases have in common is they don't involve this language where power was granted unlimited by any provision of the Constitution. That language in this context is not ambiguous. I would analogize to the big.
It's just not ambiguous language. He just says, hey, it just says it. It can't be limited by any other portion of the Constitution. It's just clear.
Case just argued before the U.S. Supreme Court about the so-called independent state legislature doctrine, Moore v. Harper. U.S. Constitution grants the legislature authority to set election rules. They're having a whole debate about whether the grant to the legislature means that the legislature is limited by the provisions of the state constitution. Well, if the U.S. Constitution said...
Are you associating yourself with the argument that's made in that case?
No, quite the opposite. If the U.S. Constitution...
Problems with this case without getting into that issue.
But if the U.S. Constitution said the state legislature was granted the power unlimited by any provision of the state constitution to set election rules, they wouldn't be having the argument, because it would be clear that the legislature's power was unlimited by any provision of the state constitution.
It's just very clear when the Constitution says that the power to enact the workers' compensation laws is given to the legislature and it cannot be limited by any other provision of the Constitution. That includes the initiative part of the Constitution that gives the people the power to pass initiatives. So it's just conflicting right. It's just running headstrong right into it. So we all know that it's an overreach by Uber and Lyft to grab more money. They spent $200 million to do it. They want more money. Greedy, 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 greedy. That's what they're doing. They're taking rights away from the people in order to make more money. They're convincing the general public to pass a proposition by 58%, only by 58%. You know, I see news articles. It was passed by a great majority of Californians. And the OC Register is just popping off articles left and right. Oh, it's the majority of it's only 58% after spending $200 million to pass Proposition 22. Proposition 22 is sneaky in 100 different ways. But the main way that it's unconstitutional is that it runs directly into the fact that only the legislature under the California Constitution can pass laws related to workers' comp, not inhibited by any other constitutional provision or amendment. So that's the way it goes. So the only way to remove the power from the legislature is to put on the ballot in an initiative that we're going to amend that portion of the Constitution. Otherwise, you're just amending another portion when that portion of the Constitution that gives the legislature full authority to enact it is still there. So you can't. You have to amend the portion of the Constitution that gives the legislature the right to enact workers' compensation laws.
And that's exactly our argument.
But isn't that, I mean, that's what I'm having trouble with, is that IEP essentially said it's not, you can't really say it's unlimited, because that would then mean that, you know, the veto power would be unavailable. And so didn't the IEP court say, well, that makes it at most ambiguous as to, you know, how unlimited we should read this?
Well, two responses. One, what the IEP court said is that the provision could reasonably be...
We're talking about a different court case that's interpreting some stuff, and I'm not going to go into that for purposes of the discussion, but here we go. Let's see what Cronland has to say.
Interpreted as non-exclusive, so that the people could exercise the power to grant additional authority to the PUC also, just like the people could create and enforce a complete system of workers' compensation also. But that's not what Prop 22 does. It's not creating and enforcing a complete system of workers' compensation. It's giving people incomplete accident insurance and taking away the legislature's power to do what the Constitution says.
But the legislature could do that, right? The legislature has accepted various people out from AB 5, right?
Just like the legislature didn't have to grant unlimited jurisdiction to the PUC, the legislature doesn't have to legislate to the full extent of its power, but it can't disable itself from having the power.
What about the words any?
It can't disable itself from having the plenary power to do it uninhibited by any other provision in the Constitution or law. So, you know, this is the stuff that's going on right now. We're going to get a decision from these three smart justices up there. I have no doubt that it's going to come down in favor of making Uber and Lyft drivers employees as they are under Assembly Bill 5. So if you're out there and you're an Uber or Lyft driver, you need to tune into my live stream so that we can go over this stuff and you can understand what's coming down, because it does appear that these judges are going to be convinced by Mr. Cronland and his briefings on this matter. I'm going to sign off for now because it's time to go home. I put in my day's worth of work. I probably have a bunch more work to do. So I'll be back tomorrow with more.